My name is Angelita Chavez. I'm a partner and immigration attorney with Chugh LLP. Today, I'll be discussing H-1B amendments with my colleague and moderator, Swapnali.Kelkar. Over to you, Swapnali.
What is an H-1B amendment?
H-1B employees must work under the conditions described in their initial H-1B petition for the duration of their employment. These conditions include work location, pay, and job duties. If there will be a material change in the H-1B employee's work conditions, the employer must file an H-1B amendment, also known as an amended H-1B petition, with the United States Citizenship and Immigration Services before the change occurs. If the amendment is denied, the employee's current H-1B status will not be affected. The denial also does not prevent an employer from filing another amendment.
Thanks for that overview, Angelita. So when is H-1B amendment required?
An amendment is required when the terms and conditions of employment have significantly changed or when any material change in the H-1B employment occurs. These changes include, but are not limited to, work location, if it moves outside of the metropolitan statistical area listed in the original labor condition application or LCA, job duties, number of hours worked, full-time or part-time status, salary, and more.
That sounds like there may be many times when an employer needs to file an H-1B amendment. When is an employer required to file an amended H-1B petition for a work location change?
An H-1B amendment is only required for work location change if the new work location is either outside of the geographical area listed on the original LCA or outside a reasonable commutable distance. If the new work location will be outside of the geographical area listed on the LCA, an amendment must be filed before the employee begins working at the new location. An H-1B employee may begin working at the new location once USCIS receives the amendment request. If the amendment is denied, then the employee must return to work at the original worksite listed in the previously approved H-1B.
What does a reasonable commuting distance mean?
There is no set time or mileage limit for reasonable commuting distance. Normal commute times may vary based on the region. However, cities within the same metropolitan statistical area will generally be considered within reasonable commuting distance of each other.
What if the work at the new location is temporary? Do employers need to file an H-1B amendment under those circumstances as well?
If the work required at the second work site is temporary, an employer does not need to file an H-1B amendment. Work qualifies as temporary if it meets the following conditions. It is short-term. The employee will not exceed 5 consecutive days at the second site in a single visit or 10 consecutive days for a traveling employee. The work is not acting as a strike bearer, or the job requires presence at another site. These rules include troubleshooting for information technology, for example.
Many employers are considering work from home arrangements for their H-1B employees. In these cases, when is an H-1B amendment needed?
Work from home arrangements will not require an H-1B amendment as long as the H-1B employee lives within the geographical area and reasonable commuting distance of the worksite listed on the LCA. However, if the employee will work from home outside of the geographical area listed on the LCA, the employer then will need to file an H-1B amendment before the employee can begin to work from home. If the employee will not exceed 36 days of remote work at their home, USCIS may grant temporary and short-term placement options on a case-by-case basis.
What if an employer needs to change multiple conditions of employment for an H-1B worker? Can they file H-1B amendments while other amendments are still pending?
It depends. In some circumstances, it may be okay to file while another amendment is still pending. However, it is not advisable to file multiple amendments at once. It is important to consult with your immigration attorney when amending an H-1B petition to ensure compliance with USCIS and Department of Labor regulations.
Thank you very much for your insight today, Angelita.
You're welcome. It is critical that employers remain compliant with USCIS and Department of Labor rules related to H-1B terms and conditions of employment. For questions regarding H-1B visa sponsorship, please contact your trusted Chugh LLP professional.
Thank you for watching.